Good morning, class. Good morning. This is the second half of the lecture this morning. Okay. Please now allow me to proceed to my desk. Good morning. Good morning. Right. It's now 11 o'clock, so that we shall resume the class. Just now we had about 10 to 15 minutes break. I think that you now become fresh. All right, and when you're fresh, then I think that you will have a lot of strengths and concentration. Okay, for the purpose of pursuing this lecture this morning. Right. We are still in the section involving the vitiation of will when the will of a party is not free, or when the will of a party to the contract is not genuine. Okay, to uh, enable you to know where we are now. Okay, look at these items again. Okay, remember we spent a lot of time, actually about 9 hours at least. Okay, talking about situations which are concerned with the vitiation of will of the party. We have looked at the situation which is concerned with a hidden intention or chetana sonren. We have also discussed the situations involving a fictitious intention, including the fictitious intention which is aimed at concealing another juristic act. Okay, the situation which is known in Thai as การแสดงเจตนาลวง or การทำนิติกรรมอำพราง okay, and we have talked about the situations involving fraud, and just a while ago, okay, in the first half of the lecture, we have talked about the doctrine or the principle of juris, okay, the juris situation which is concerned with the extension of the threats. Okay, so right now we will move on to look at one more principle of law. Okay, this is the principle of law, the principle of mistake or ความสำคัญผิด. Okay, we will take about, I think that in 1.5 hours. Okay, talking about this. Now, mistake, or in Thai ความสำคัญผิด. What is it? Of course, it carries just the plain language. It is sort of the misunderstanding about some crucial facts. Okay, at the time of the conclusion of a juristic act. That means that when A and B makes a juristic act, one of the parties has made some mistake. One of the party makes, or even both parties, okay, make a mistake as to some crucial facts at the time of the conclusion of that juristic act. Right. So we can see that when a juristic act is procured or is made under mistake like this, right, the intention as declared may not be a genuine one, right, because one of the party or even both party is or are under mistake, right. So to begin with, we will look at the types of mistake and legal consequences of mistakes in Thai law, right. In Thai law, right, we just distinguish mistake into two main types. The first one, it is the mistake as to an essential subject matter of a juristic act. Okay, in Thai we call this one สำคัญผิดในสิ่งซึ่งเป็นสาระสำคัญแห่งนิติกรรม. Okay, this is the first one. Okay, as contained in section 156. With respect to this type of mistake, the consequence of this mistake is that the juristic act in question will become void, because this is something very serious. Right. By way of comparison, we have another type of mistake. It is the mistake as to the quality of a person or of the property. Okay, it is not the mistake as to the essential subject matter of the juristic act, but it is about some quality The quality of what? Quality of a person or quality of the property in question, okay? In this case, the mistake is less serious than the one of the first type, so that the legal consequence, okay, in the CCC is that the Juristic Act in question will become just voidable, not void. Okay, this is pronounced in the section 157, paragraph 1. So we have 156, paragraph 1 and 157, paragraph 1. 156, paragraph 1 deals with the mistake and a mistake as to an essential subject matter of a Juristic Act, while 157, paragraph 1 deals with a mistake as to the quality of a person or of the property. Okay, so now we will move on to look at each type of mistake, as contained in 156 paragraph 1 and 157 paragraph 1. Maybe we will look at what is said in 156 paragraph 1 and 157 paragraph 1 first. 156 paragraph 1 provides as follows: the declaration of an intention under a mistake. The declaration of an intention under a mistake as to an essential subject matter of a Juristic Act is void. So this is the first type of the mistake. Okay. Now 157 paragraph 1, which deals with the second type of the mistake. The declaration of an intention under a mistake as to the quality of a person or of the property is voidable. So now we begin with the first type of the mistake, i.e. the mistake as to an essential subject matter of a Juristic Act. What is it when we deal with a mistake as to the so-called essential subject matter of a Juristic Act? What is it? Well, it is something which is, it is a mistake about something which is so fundamental in the Juristic Act in question, okay? Something very, very, very important, okay? If I try to put it, if I try to simplify it, do we have examples of, examples of a mistake as to an essential subject matter of a Juristic Act? ปริญชัยความสำคัญผิดในสิ่งซึ่งเป็นสาระสำคัญแห่งนิติกรรม Well, if we look at section 156, paragraph 2, remember we have 156, paragraph 1, which says that a mistake as to an essential subject matter of a Juristic Act is void. And then paragraph 2 of the same provision goes on to provide three examples of this kind of mistake. The mistake as to an essential subject matter of a Juristic Act. Okay, paragraph 2 say this. Okay, paragraph 2, we look at paragraph 2. A mistake as to an essential subject matter of a Juristic Act under paragraph 1 are by way of illustration, okay? That means that these are just examples. Okay? A mistake as to the nature of a Juristic Act. So this is the first example. The mistake as to the nature of a Juristic Act. Right. How about the second one? Back to 156 paragraph 2, okay? A mistake as to the person that is a party to a Juristic Act. See, so this is the second one. The mistake as to the person that is a party to a Juristic Act. And how about the last one, the last example? And a mistake as to the property that is the subject matter of a Juristic Act. See, the property, which is the subject matter of a Juristic Act. Okay, these are the three examples 1, 2, and 3. The three examples of the mistake as to an essential subject matter of a Juristic Act. Right. A mistake as to the nature of a Juristic Act. ของอินไทยสำคัญผิดในลักษณะของนิติกรรม a mistake as to the person that is a party to a juristic act สำคัญผิดในบุคคลซึ่งเป็นคู่กรณีแห่งนิติกรรม and the last one the mistake as to the property that is the subject matter of a juristic act สำคัญผิดในทรัพย์สินซึ่งเป็นวัตถุแห่งนิติกรรม now we are coming to discuss the first example the first example of a mistake as to an essential subject matter of a juristic act is the mistake as to the nature of a juristic act สำคัญผิดในลักษณะของนิติกรรม what is it it is the mistake about what about the nature as the heading suggests that means that a party is mistaken a party has the misbelief that the juristic act in question it is one juristic act but in fact it is something else it is in fact a different one when A and B for instance make a contract A thinks that A has the misbelief that it is one juristic act but in fact it is a different juristic act okay let's say that A thinks that he signs a guarantee but in fact it is not a guarantee it is a loan agreement A is mistaken that he is signing a guarantee but what is being signed it is not a guarantee it is just a loan agreement so he thinks that it is one juristic act but in fact it turns out to be a different one well for your information okay this is something very very similar to the non-a factum case in English law we will explore English law maybe next week and we will see that with respect to mistake there is the situation known as non-a factum this is the Latin expression okay meaning it's not my deed okay don't worry if you do not know it now we are going to cover this okay non-a factum doctrine next week not right now right so let's have a look at before going to that let me just remind you again that the reason why we have to explore also English law it is for the comparative purpose okay we look at English law in comparison with Thai law so that you will see that English law has more things than what we see in Thai law and then the insight into English law may just give you an idea as to how to amend or how to just make change to Thai law in order to effort greater protection okay to the parties who suffer some injury from the situation in question okay now let's have a look at the example of the mistake as to the nature of a juristic act สำคัญผิดในลักษณะของนิติกรรม remember it is a case where A thinks that he makes one juristic act but it turned out to be a different juristic act in fact it is a different juristic act but A thinks that it is one juristic act but it is in essence it is in fact another juristic act which is totally different from the one he believed okay to be right now let's look at example here I just been turned on the air conditioner just now I get cold so I switch off the air conditioner now I put it back okay good let's have a look at the example of a mistake as to the nature of a juristic act okay let's suppose that we have here Amy and whom we have Amy and Amy's son okay she intended to act as a guarantor Guarantor is somebody who just that makes a guarantee. สัญญาค้ำประกัน in Thai, okay? There are two terms for this agreement, okay? The person who acts, a person who make a guarantee, it is called a guarantor. You can call that person as a surety. So these two terms are interchangeably used. So Amy intended to act as a guarantor for the loan agreement, for the loan extended to her son, okay? And she was asked to sign a written agreement. Amy thought that she signed, a guarantee agreement or suretyship. Guarantee agreement and suretyship, these two words are also, interchangeably used. Right. Amy thought that she signed a guarantee agreement, but in fact it was not a guarantee agreement. It was in fact a loan agreement. She thought that she signed a guarantee agreement, but it turned out to be, in fact, a loan agreement, okay? So, she thought that it was a guarantee agreement, but in fact, in essence, the real essence of this agreement is not a guarantee agreement, but it is a loan agreement, okay? So we can see that there is also the difference between the inward intention and the outward intention. In her mind, Amy thought that it was a guarantee, but in fact, it turned out to be a loan agreement. So the outward intention was to make a loan agreement, but the inward intention, the genuine intention, was to make a guarantee agreement. Right. So now, we can see that in this case, Amy was, in a way, mistaken about what? Mistaken about the nature of a juristic act. สำคัญผิดในลักษณะของนิติกรรม Right. So when we deal with this situation, okay, the question is, can Amy allege that the loan agreement is void because it has been made under mistake as to the nature of a juristic act? Can she claim that, okay, she wanted to make a guarantee, but it turned out to be the loan agreement? So, right, our intention would not be given legal effect by law, because our intention was not her real intention. Her intention was to make a guarantee. Right. So the answer is that yes, in this kind of case, right, when in the person's mind, the person think that the person makes one juristic act, but in fact it turned out to be a different one. The mistake like this, it is something very, very fundamental, so that the juristic act in question cannot be given legal effect. So it must be void. Right. So the answer is that Amy, in this case, can allege that the loan agreement becomes void because it has been made under mistake. The mistake as to the nature of a juristic act, which is indeed a mistake as to what? An essential subject matter of a juristic act. Right. So we can have this diagram, okay, for ease of your understanding, okay? Amy, she thought that she signed a guarantee, but in fact it turned out to be a loan agreement, naming her as a co-borrower or a borrower. In this case, Amy did not intend to be bound by this loan agreement. She did not want to be a borrower. She just wanted to be a guarantor. So that in this case, it is a mistake as to the nature of the juristic act. So that this juristic act will become just void. Right. It will become just void. Okay, under section 156 per 156 of the Civil and Commercial Code, because this is a mistake as to the nature of a Juristic Act, which is one of the example of what? One of the example of the mistake as to an essential subject matter of a Juristic Act. The consequence is that this Juristic Act is void under section 156 paragraph 1. Right. This is something very, very simple, okay? Very, very straightforward indeed. Right. Now, let's have a look at, let's move on to have a look at the second example of a mistake as to an essential subject matter of a Juristic Act. Remember the second example, it is what? The second example of the mistake as to an essential subject matter of a Juristic Act is this one. A mistake as to the person being a party to a Juristic Act. Okay, the person being a party to a Juristic Act. That means that when A and B makes a Juristic Act, when A and B make a Juristic Act, let's say a contract between A and B, one party, let's say A, one party is in the misbelief that it is a Juristic Act made with or with respect to one person, but in fact, it turned out to be made with or with respect to a different person. So this is also something very, very fundamental, so that there is no reason for letting this Juristic Act stand. Okay, let's have a look at one example here. Okay, let's have a look at one example. Right. Let's suppose that we have somebody here who was trapped in the car accident like this. They say that he was in danger, in fact in life danger like this, right? And the person, the one who was the rescue, who was the rescue people, who was one of the rescue team, he came to the scene and he held the one who was trapped in this dreadful accident. Right. The victim of this accident felt very, very grateful for the help given by this rescuer, so that right, when this man, the one who was trapped in this accident and was rescued by the rescue team, right, when that one who was trapped escaped this danger because of the help given by this rescue team, the victim felt so grateful, so that when the victim, that runs a company, he wants to have this rescuer, he wants to have this rescuer by offering employment at his company. This man, let's suppose that this man's name is Andy, This man, the victim of this accident, tried to help the rescue man by offering employment to this rescue man. This rescue man's name is, let's suppose that he is Thammasat. But the victim of the accident, by mistake, when he prepared a contract, he put a wrong name in the written contract. Rather than putting the name Thammasat here, Andy put the name Somkiat in the agreement. So rather than having Thammasat as the employee, the agreement just stated Somkiat as the employee. We have a juristic act here, a contract between whom and whom, between the Andy, or Andy's the company, and whom, and Somkiat. In fact, And the company that did not want to employ Somkiat at all, but the thing is that the name Somkiat was put into this contract by mistake. Alright. So that, of course, there is here a conflict between an inward intention and an outward intention. Okay. In his mind, Andy wanted to employ whom? Wanted to employ Thammasat, not Somkiat. But because of the wrong indication in the contract, because of the putting of the wrong name, the contractor stated Somkiat as, the employee. So that what turned out to be, what is our intention? Okay, was not what? Was not the genuine intention of the party. In this case, the contract or the jurisdiction in question was procured by mistake, or it was made under mistake. And this is mistake about what? Mistake as to the person being a party to a jurisdiction. Remember, a mistake as to the person that is a party to a jurisdiction. It is one of the examples of a mistake as to an essential subject matter of a jurisdiction. So that in this case, the jurisdiction, i.e. the contract here, the contract of employment will become just void. According to what? Let's get back into what the law say here in section 156. It will become what? It will become void because it is a mistake as to an essential subject matter of a jurisdiction. Remember, according to 156 paragraph 1 and 156 paragraph 2 gives an example of this kind of mistake by saying that one of the examples of the mistake as to an essential subject matter of a jurisdiction, it is the mistake as to the person that is the party to a jurisdiction. So if we get back to this situation, the one in which Andy wanted to employ, Thammasat, but put the wrong name into the contract of employment so that Somkiat became an employee instead of Thammasat. So an employee, the contract of employment here, which is of course a jurisdiction, will simply become what? Become void according to section 156, paragraph 1. Right. Now, let's move on to the third example. The third example of a mistake as to an essential subject matter of the jurisdiction. Okay. The third example, it is the mistake as to the property. The property that is a subject matter of a jurisdiction. สำคัญผิดในทรัพย์สินซึ่งเป็นวัตถุแห่งนิติกรรม That means what? That means that a party is in a misbelief that the jurisdiction in question it is made with respect to the particular property, but in fact it turned out to be made with respect to different property. Okay, so property to the jurisdiction, it is something also very fundamental. So when let's say A makes the contract with B in the misbelief that it is involving, this property, but in fact it involves different property, so that there is no reason for upholding this jurisdiction. So in this case, this jurisdiction will have to be void. Let's have a look at this example here. Okay, we have an agreement. Okay, we have a contract between A and B. We have A and B here. A just intended to sell his Honda Civic. So the property here, the property which is the subject matter of this jurisdiction is a Honda Civic owned by A. A wanted to sell it for 800,000 baht, selling this car from A to B. Okay, A wanted to sell this Honda Civic, but when he drafted the contract, he just made a wrong statement. Rather than stating this car as a Honda Civic, he just misstated as a Honda Accord. In fact, A has both Civic and Accord. He wanted to sell a Civic, but by mistake, he just put the wrong, indication, indicating the car as a Honda Accord, which he also earns. So, we have a contract between A and B, a sale of a Honda, but the contract just misstates the car. The contract by mistake indicates that it is a sale of a Honda Accord, okay? So, this is a mistake which is very, very fundamental. It is a mistake about the property that is a subject matter of a Juristic Act. So when it is a mistake about something so fundamental, there is no reason for upholding this contract. This contract should be, what? This contract should be void. Remember, different legal consequences in the case of a mistake as to an essential subject matter of a Juristic Act. It will be void, but if it is mistake about the quality of the property or of the person, the Juristic Act in question will become merely voidable, not void. We will turn to that later. Right? Now, we have seen these three examples of what? Of a mistake as to an essential subject matter of a Juristic Act. Remember, one is the mistake as to the nature of a Juristic Act. The second one, it is the mistake as to the person, that is the party to a Juristic Act. The last one, it is a mistake as to the property, that is the subject matter of a Juristic Act. Now, can I ask you this question? Apart from these three examples, are there any other cases beyond these three examples? Remember, these three cases are just by way of illustrations. That means that there are just examples. So the list of examples of the mistake as to an essential subject matter of a Juristic Act as given by Section 156, paragraph 2, it is a non-exhaustive list. So these three cases are just examples. That means that, there are also other cases of a mistake as to an essential subject matter of a Juristic Act beyond these three examples. So do not be mistaken that these three examples are exhaustive ones. There are not exhaustive ones, So we can say many other cases of a mistake as to an essential subject matter of a Juristic Act. We can draw other examples from decisions of the Supreme Court. We have one decision of the Supreme Court. The facts in this case are something like this. I try to simplify these facts. I try to give you the fact with some modifications in order to maintain simplicity to ease your understanding. Let's suppose that we have A and B. This Juristic Act is concerned with a list. A list. When A and B, let's suppose that A and B, this is A, this is B. When they make a list, The one who grant a list is called a lessee. Sorry, the one who take the list, it is called a lessee, ผู้เช่า. The one who grants a list is called a lessor, ผู้ให้เช่า. In a list, one thing which is very, very important, also fundamental, it is the rent, ค่าเช่า. Okay. In this case, A rented a house from B, and A was in the misbelief about the rent. He thought that the rent was 5,000 baht a month, but in fact, the contract stated that the rent was 7,000 baht per month. But the lessee was in the misbelief that the rent was just 5,000 baht per month. In fact, it was 7,000 baht per month. Okay. Now, when A, the lessee, knew the truth about the rent, about the amount of the rent, the lessee tried to claim that this list was void on the ground of a mistake as to an essential subject matter of a Juristic Act. We can see that this mistake does not fall in one of these three examples given by Section 156, Paragraph 2, but the Supreme Court held that even though it is not listed in 156, Paragraph 2, even though it is not one of these three cases, but it is also a mistake as to an essential subject matter of a Juristic Act. Because what? Because rent in a list, it is something very important. It is an essential element of a Juristic Act. So that when the lessee was mistaken about the amount of the rent, the lease agreement here would become void because of the mistake as to an essential subject matter of a Juristic Act. Under Section 156, Paragraph 1 as well. Right. That is one example. Okay, remember, according to the Supreme Court, rent is something very, very important. Rent is something so fundamental. So that when a party is mistaken about an amount of rent, that is a mistake as to an essential subject matter of the Juristic Act. Now, coming to another case as brought before the Supreme Court, it was concerned with a contract of sale, and the facts of this case seem to be quite similar to the facts in the previous case which we mentioned earlier. But it is not about the rent because this is a sale, so the mistake related to what? A price. A sold land to B. Whatever it is that A's broker, in this case A engaged somebody to be his broker for the purpose of this sale. So the broker engaged by A, okay, fraudulently made a false statement to B, so that in this case B was mistaken about the value of this land, but the mistake was also occasioned by the false statement given by whom? Given by A's broker. So when the A's broker gave this false statement, A would have to be responsible also for the false statement made by his broker. His broker, they acted as, in a way, as A's agent, so that, A would have to be liable for the act or the conduct by the agent as well, right? So, there was a mistake in this case about the value of the land, the value of the property sold under the sale contract. In this case, that there are the facts. When the fact was concerned with the false statement given by one party or the party's agent, okay, so we can see two principles of law. The first one is the principle of fraud. The second one is the principle of mistake. we have seen that sometimes we can have possible duality of legal principle. That means that one set of facts may trigger two principles of law at the same time. That is possible. So in this case, when a broker gave the false statement, okay, with the intention to deceive, that is also fraud. Remember, we have dealt with the doctrine or the principle of fraud in Thai law. So that in this case, the party who became injured, that is who? That is B, okay, the buyer, could just invoke, in fact, two principle of law, the principle of law regarding fraud and the principle of law regarding mistake. We can see that, the legal consequences are different if the injured party just invokes the principle of mistake, then the consequence is that the Juristic Act will become, if the party invokes, the principle of fraud, the consequence is that the Juristic Act will become voidable. But if the party invoke the principle of mistake, by claiming that this mistake is the mistake as to an essential subject matter of a Juristic Act, then the consequence is that the Juristic Act will become void. So when there are, two principle of laws to apply like this, right? The party who suffer injury can have choices, right? So which choice it is the best one? Right. In this case, it was held by the Supreme Court that, this sale, of course, the Juristic Act, was made both by fraud and also it was made as a mistake as to an essential subject matter of a Juristic Act. So we can see that the Supreme Court witnessed duality of legal principles. When there was fraud, then the sale was voidable. Remember, under Section 159. Okay? And when it was also a mistake as to an essential subject matter of a Juristic Act, this sale was also, what is consequence? Void. The Supreme Court held that this mistake, the mistake like this, it was also the mistake as to an essential subject matter of a Juristic Act. Why? Because the price was something as important as the property itself. The price of the property sold, it is something equally important. Okay, it is as important as the property. That is the subject matter of the Juristic Act. Right? So, we can see that the same facts in this case trigger both the doctrine of fraud and the doctrine of mistake. Okay? According to the principle of law regarding fraud, the sale in question would become voidable. But according to the principle of law, the principle of mistake, this sale would become void. So the party here, the buyer, would have to choose what? In this case, it seemed that the Supreme Court made a choice for the party. The Supreme Court said that, given the duality of principles of law to be in operation like this, then we, the court, will have to choose what is best for the party. The court said that, this sale, this Juristic Act, would have to be treated as void on the ground of mistake. Why? Because treating it as void on the ground of mistake would be more favorable to the declarer of the intention, than to treat it as just voidable. Even though that it could be both voidable and void, it was voidable on the ground of fraud, and it was void on the ground of mistake as to an essential subject matter of a Juristic Act. But the Supreme Court would treat it as void rather than voidable, because again, treating it as void on the ground of mistake would be something more favorable to the declarer of the intention, okay, than treating it as voidable. Put simply, the Supreme Court here, okay, made the choice, okay, on behalf of the party. In fact, it should be up to the party to choose, but in this case, the Supreme Court just thought that it would be best to just choose the remedy for the party. Okay, given that treating the contract here, treating the sale here as void, it would be more favorable to the party under mistake, then we, the court, would have to choose for the party. Right. So you know that I have made an indication before that sometimes the same facts or the same set of facts may possibly trigger both doctrines or both principles of law at the same time, so that the parties may make an election. Okay, the parties may make a choice, the choice which best suits his or her own interest. So it is not weird that that sometimes the same facts or the same set of facts just trigger both or even more than one principles of law. Maybe even the two principles of law, or maybe even in rare cases it may trigger three principles of law. That is also possible, right? Now, let's have a look at another example of what? Another example of a mistake as to an essential subject matter of a Juristic Act, beyond the three examples which are provided by Section 156, paragraph 2. Okay, even though the case, the facts, do not fall within one of the three examples as provided by Section 156, paragraph 2, but it is still regarded as a mistake as to an essential subject matter of a Juristic Act. In this example, if there is a mistake, okay, a mistake about what? About what's going on, okay? About what's going on. About the transaction, okay? When one party make a transaction without understanding that transaction at all, maybe even that person was told to make that Juristic Act without knowing that transaction at all. In this kind of case, in such a case, it can be a mistake as to an essential subject matter of a Juristic Act as well. We have on this point an example drawn from this Supreme Court case in 1987. Okay. Again, for simplicity, I would like to just put the facts into the diagram here. Let's suppose that there is a man, A. This man is A, and A's wife is B, and A and B has a child, okay, has a son, say C here. So A is the man, the husband, B, the wife, and C, the son. What happened is that this man died. When this man died, of course, this man left behind a lot of property. So the property form part of the estate. Okay. So the wife, B, in fact, when A died, B, the wife, at the time B was also old. So B, the wife, was appointed as what? As the arbitrator of the estate. The arbitrator of the estate, we call in Thai ผู้จัดการมรดก. Okay, what is the duty of an arbitrator of the estate? the duty of the administrator of the estate is to do what? Is to distribute property which form part of the estate to all heirs. Okay. So the distribution of estates among all heirs. This is a very important duty or obligation of the administrator of the estate. Let's suppose that this man has many items of property. So this lady, the wife, who was appointed as an administrator of the estate, would have to distribute properties. Okay, of this meant the property which form part of the estate among all heirs. Let's suppose that this man has many children, or this man has also parents. Then the property which form part of the estate, okay, would have to be distributed among all heirs. But the thing is that this son wanted the land which form part of the estate, okay? The estate in Thai we call this one called Murado. Right? What this son did was this. This son knew that, his mother was very old and the mother did not seem to understand things at all. So the son made all arrangements, okay? The son just made all arrangements. And the son just asked the mother to go to the land office to do what? To first transfer. He wanted the mother to just transfer the land and house which form part of the estate to the mother first, and then to sell that land to C. I hope that you get the clear picture. This child just got his mother to go to the office to transfer this land to the mother first, and then to sell this land to him. Right? But the mother did not understand at all what's going on. The mother just relied on the son. The son made all arrangement. Here, we have in this case some juristic acts. I.e. first, the transfer of land to the mother, the transfer of land from A to B, and secondly, the sale of land from B to C. So these two juristic acts were made by mistake. Okay? Given that the mother did not understand at all, the mother did not understand what was going on with respect to these two transactions. So when the mother did not understand this juristic acts at all, the mother just did what was told by the son. All arrangements were carried out by the son. It was therefore held by the Supreme Court that these transactions were made under mistake, and it was the mistake as to essential subject matters of the juristic acts. So that these transactions, i.e., the transfer of land to B, to the mother, of course, and the sales of land from B to the son, the sale of land from the mother to the son would be void because these juristic acts were made by mistake as to essential subject matters of the juristic acts. Under Section 119 in the CCC at that time has now become 156 of the CCC at present, okay? So, when these transactions became void, the official registration, okay, of the transfer of the ownership in the land would have to be cancelled or annulled. as if when there were no transfer at all. Right. So we can see, in a situation where the party does something, the party performs something without real understanding of what's going on, without real understanding. Okay, it is something close to the mistake as to the nature of a juristic act. Right. So that according to the Supreme Court, this is also considered as a mistake as to an essential subject matter of a juristic act. So that the juristic act in question will become void as well. So when it becomes void, we will see consequences of voidness later. When it becomes void, it will have to be treated as nullity. Okay, as if there were no such thing, no such juristic act at all in the first place. So that the land would have to be, back to the estate of the deceased in order to be distributed among all heirs. Now, look at one more example here. Okay, in this example, it is concerned with the sale of land when, in fact, the seller had no lawful title in the land. Okay, let's suppose that we have the seller here. The seller here sold this land to the buyer. At that time, the seller did not have any title in this land. Okay, this land in fact carried, possessory right, but in fact, A did not have any possessory right in this land, but B, when B bought the land from A, B believed, and it was the misbelief that A had, a lawful possessory right in this land. In fact, A did not have any possessory right in this land at all. So when B bought this land under this misbelief, it was held by the Supreme Court that when B misbelieved that A had a lawful possessory right in this land, right? So that the sale in question, would have to be void because it was made by mistake as to an essential subject matter of a juristic act. We can see that even though this kind of mistake does not fall within one of the three examples in section 156 paragraph 2, but it is the mistake about something so fundamental, so that the Supreme Court here that is the mistake as to an essential subject matter of a juristic act here, so that this sale would have to become void. When it was void, that means that both parties would have to effect. Both parties would have to do what? Okay, we would have to apply the provision of law on undue enrichment. Okay, so that A, the buyer would have to do what? Would have to return the price to B, and B would have to just return the land. If B did not yet take the land, B would not have to take the land, okay? But B, if B had paid the price, B would have to get the return of the price, okay? Right. We will have to explore the legal consequences of voidness later, okay? When when a juristic act is void, the law say that we will have to apply provisions of law on undue enrichment among the parties. So if the buyer has received the property, the buyer will have to return the property. If the seller has received the price, the seller will have to return the price to the buyer. Right. So again, in this case, it is concerned with the sales of land without the seller having a title in the land, but the buyer misbelieved that the seller had a title in the property. Okay? When the Supreme Court held that this triggered, the principle of law on mistake. Right. I would like you also to be aware that in addition to the application of the principle of mistake, if you are the buyer in this case, you can also resort to remedies based upon eviction. The eviction in Thai we call การรอนสิทธิ์ I hope that you have taken a lesson on eviction, okay? You have taken, the law on specific contracts. A contract of sale is one of the specific contract when A sells something to B. B expect to have the ownership in that property. But if after the contract has been made between A and B, and it turned out to be that, in fact, B cannot have the property because somebody else, okay, has the rights over that property. Let's suppose that A is not the real owner, and A just sells something to B. In fact, the real owner is C. In this case, B suffers eviction of การรอนสิทธิ์ Okay. In this case, B can have remedies like this. B can just claim damages for eviction. B can also demand a return of the price. B can also refuse to take delivery. Okay. So apart from the principle of law, apart from the principles of mistake, B, the buyer, can also have resort to remedies based upon eviction, okay, under section 475 or 479 in the civil and commercial code as well. Right. Now, we have seen examples of what? Example of something which is regarded as a mistake as to an essential subject matter of a Juristic Act. Now let's have a look at some cases in which it has been held that is not about a mistake as to an essential subject matter of a Juristic Act. Okay. In one case, which is of course a Supreme Court case, we have, the sales of land from A. We have a sales of land from A to B. Okay. Sometimes, when A wanted to sell the land to B, sometimes, the party sometimes would make, just an agreement to sell first, or สัญญาจัดซื้อจัดขาย An agreement to sell, it is an agreement whereby the parties just agree to be bound initially, and okay, they promise to do one thing in the future. The seller promises to do one thing in the future. That is to register the sale and transfer the ownership from the seller to the buyer in the future. Okay, so A would have an obligation to transfer the ownership in the land to B. The thing is that, okay, the A registered the sale and transfer the land to B because A was mistaken. A was in the misbelief that B had transferred the money to the bank account, to A's bank account. In fact, B had not yet transferred money to A's bank account yet. Right. So due to this mistake, due to this misbelief, A transferred the land to B. So we have a Juristic Act here, the transfer of land from A to B. Had A known that B had not yet paid the price, then A would not have registered the sale for B at all. Right. It was held by the Supreme Court that in this case, right, in this case, the sale was what? The sale was voidable on the ground of fraud. You may wonder why is fraud? The thing is that on the facts, B, the buyer, just told a lie to A as well that he had made payment by transferring the money to A's bank account. So when it was also the false representation or misrepresentation by B, the buyer, with an intent to deceive A, it was also fraud. Okay, so the registration of land here would have to become voidable. The sale was voidable on the ground of fraud. Under section 159, which we have dealt with before, remember. And A, the seller, could avoid this registration. A, the seller could avoid this sale, of course. Right. It was also held by the Supreme Court that in addition to the principle of law on fraud, right, the sale in question here was not void. The court would have to consider whether or not it was possible that this sale would become void as well on the ground of mistake, and the court said that the mistake in question, okay, did not amount to a mistake as to an essential subject matter of a Juristic Act, so that it was not void, the sale was not void on the ground of mistake, but it was just voidable on the ground of fraud. So we can just say that in this case, when the seller was in the misbelief that the buyer had made the payment to the seller, and based upon this misbelief, the seller transferred the property or transferred the ownership in the property to the buyer, that was not enough to constitute the mistake as to an essential subject matter of a Juristic Act, according to the Supreme Court's opinion. Okay, that was decided by the Supreme Court in the 2007. Okay, now have a look at the more example here. I think that I have to exceed the teaching time a bit. Okay, now is 12:09. I try to just finish my lecture before 12:30, or possibly, okay, my lecture time may be exceeded by a few minutes. Okay, so sorry about that, but I try to just finish it on time. Okay, now we are going to look at another example in which the Supreme Court believed that the mistake in question could not amount to a mistake as to an essential subject matter of a Juristic Act. In this case, it was concerned with the purchase of land. The land was sold by auction, okay? The land was sold by auction. It was sold by, in fact, the execution officer. In Thai we call this one เจ้าพนักงานบังคับคดี okay? So when it was sold in auction or by auction, okay, that means that many people would have to bid. Normally the property would be sold to the one who offered the best price or the highest price. The thing is that the buyer here just made a bid in the misbelief that this land was free from what? Was free from any mortgage. In fact, this land was still under a mortgage. But this buyer who just bid for this land was in the misbelief that this land was free from any mortgage. Right. So when this buyer, happened to know the truth that this land was still under the mortgage, the buyer just felt very upset, and the buyer just claimed that this auction sale became void on the ground of a mistake. That means that the buyer just believed that that was a mistake as to an essential subject matter of a Juristic Act. So the Supreme Court would have to consider whether or not the mistake in question here, it is a mistake as to an essential subject matter of a Juristic Act. สำคัญผิดในสิ่งซึ่งเป็นสาระสำคัญแห่งนิติกรรม Okay, and it was held that this mistake did not amount to a mistake as to an essential subject matter of a Juristic Act. So the sale here was not void. Remember, that we have seen that a mistake as to an essential subject matter of a Juristic Act. That means it is a mistake about something so fundamental. Sometimes, that it seemed to be sort of, personal feeling by the court. In some cases, the mistake which seemed to be very important is, in the opinion of the court, a mistake which does not amount to a mistake as to an essential subject matter of a Juristic Act. But in some cases, the mistake in question is regarded by the court as a mistake as to an essential subject matter of a Juristic Act. Right. So that seems to be quite hard, to have a clear answer indeed. Okay. Now we are moving on. To discuss another type of mistake. Remember, just now we talked about the mistake under section 156, i.e. the mistake as to an essential subject matter of a Juristic Act. The consequence of which is that the Juristic Act in question will become void. Now we are moving on to consider the mistake as to the quality of what? The quality of the person or of the property, okay? The quality of the person or the property. It is a mistake about certain quality of the person or of the property in question, okay? But that quality must be considered as essential in the ordinary dealings. Without that mistake, the Juristic Act in question would not have been made. In this kind of case, the Juristic Act in question will become just voidable, not void, because it is less serious than the mistake as to an essential subject matter of a Juristic Act. Okay? Remember the provision of law here, it is section 157. 157, paragraph 1 provides as follows. The declaration of an intention under a mistake as to the quality of a person or of the property is voidable. And paragraph 2 elaborates upon this point by saying that the mistake under paragraph 1 must be one as to the quality which is in the usual course of things regarded as essential. So we have to consider the usual course of things or the usual course of dealings. That quality must be essential in the usual course of things or the usual course of dealings. Otherwise, that quality will not lead to the Juristic Act in question becoming voidable. Let's have a look at example number 1 here. Let's suppose that it is a case of employment of an interpreter, okay? Let's suppose that we have A and B. Okay, B is an interpreter, okay? A wanted to employ an interpreter who would have to have A's company, okay, in the running business projects in Belgium. Of course, in Belgium, one of the official languages is French. So that A wanted to employ somebody who was fluent both in English and French, because French is also necessary in Belgium, okay? So when A employed B, A was mistaken that B was fluent in both English and French, but in fact, B only knew English, not French. Right. So when A employed B, A employed B on the basis that B had fluency in both English and French, but it turned out to be that B has been fluent only in English, not French. So in a way, the mistake in question, it is about the quality. Quality of whom? Quality of a person. Okay. The mistake about the quality of a person. So according to section 157, the contract here, the contract of employment here would have to be voidable on the ground of a mistake as to the quality of the person. Right. And remember, paragraph 2 of 157 say that this quality must be essential in the usual course of things. I think that if we consider these facts, we can see that this quality, i.e. the knowledge of the French language, is essential because in Belgium, okay, people speak French, many contracts, many arrangements are to be performed, are to be prepared in French as well, so that in the usual course of things or usual course of dealings, this quality, i.e. the knowledge of the French language, it is essential. So that the consequence of this case is that the contract of employment will become voidable on the ground of mistake. Now we are going to look at some examples which have been drawn from the Supreme Court decisions. In one case decided by the Supreme Court in 1988, right. This case was concerned with a contract of employment by a state enterprise, okay, and an employee. In this country, we have a piece of legislation known as, the Acts on. I think that one thing is missing. Okay, I forgot to just put the word under the Acts on. Can you just add the word Acts on? Under the Acts on standards, qualifications. Okay, standard qualifications for directors and officials of state enterprises. Right. A director and an official of a state enterprise must not be over 60 years of age. This act sets, the age limit. A director or an official of a state enterprise in this country must not be over 60 years of age. The thing is that the employee in this case, at the time of making the contract of employment, was over 60 years of age. But the thing is that his birth certificate was erroneous. Okay, his age was false. Okay, the indication on the birth certificate was false, so that the state enterprise was in the misbelief that at that time that employee was below 60 years of age. In fact, at that time, that meant the employee, potential employee, was over 60 years of age. So when the state enterprise knew the truth about the age, the real age, the state enterprise, they wanted to do what? The state enterprise wanted to just discontinue the employment, discontinuance of the employment. In fact, in essence, it was equivalent to what? Equivalent to avoidance of the contract of employment on the ground of what? On the ground of mistake as to the quality of the person. Put simply, this state enterprise just tried to claim that the contract of employment was made at a mistake of quality because it thought that it's misbelieved that at the time of making the contract, that man was not yet 60 years of age, but in fact, at the time he was already over 60 years of age, so that when the state enterprise was being taken like this, it was a mistake as to the quality of the person, hence making the contract voidable. Correct. And the Supreme Court agreed, the Supreme Court held that, yes, in this case, this contract of employment became voidable on the ground of mistake, as to the quality of the person. Right. So when it was voidable, and the state enterprise could just do what? Could just avoid the contract, the Juristic Act. Now, what is going to be the consequence? Well, we have not yet explored consequences of voidable or void Juristic Act yet, okay? But for your information at the moment, okay? Let me just tell you that according to section 176, paragraph 1, okay, when a voidable Juristic Act is avoided, okay, upon avoidance, it shall be deemed to have been void ab initio, that means from the beginning. When it is avoided, when it is avoided by the party who suffered injury, okay, that Juristic Act will be considered as void ab initio, and the parties shall be restored to their original positions. That means that, if this man, the employee, okay, had received money as salary, he would have to return, the salary. If this employer, i.e. the state enterprise, received, some services by this man, then the state enterprise would have to return the services. But how to return services? Let's say that this man had performed some work for the state enterprise. How could the state enterprise, return the work? Impossible. So that section 176, paragraph 1, say also, at the ending part, that if it is impossible to effect such restitution, the parties shall instead be entitled, and you put the D as well. Okay, the D is missing here. The parties shall instead be entitled to damages in compensation therefore. That means that if it is impossible to return something, then the person who has received that thing will have to make compensation. Okay. In this case, would it be possible for the state enterprise to return services? This man had already performed some services for this state enterprise. Would it be possible for this state enterprise to return services? The answer is no. So in this case, this trigger, this ending part of section 176, so that this state enterprise would have to just pay damages to this man instead. And in this case, okay, the Supreme Court said that, well, in this case, this state enterprise could just return services by what? Sorry, the state enterprise would have to just pay damages by allowing this man to have the money previously paid, okay, without this man having to return the money to the state enterprise. So, okay, so the money here, the salary which had been received by this man, did not need to be returned because it could be considered as the compensation, okay, to be made by the state enterprise, okay, in compensation for what? In compensation for the services already rendered by this man, okay. So that according to the Supreme Court, this man did not need to return the salaries because this is considered as a what? This is considered as damages made by this state enterprise for the impossibility of restitution, okay? Because it was impossible for this stated price to just, to just what? To just return the services rendered by this man, so that, this stated price would have to just, the make compensation by allowing this man to retain the salaries which had been received by this man. All right. Now have a look at more example here. There are many other cases in which the Supreme Court believe that the mistake in question, it is the mistake as to the quality of the person or of the property. Okay. In one case decided by the court in 1998. Okay. It was about a lease of land and a building. Okay. A wanted to take a list of the land and the building from B. Okay. At that time, A didn't know that in fact this land was in the area covered by the expropriation plan. In fact, the government wanted to expropriate this land in the near future. A wanted this land and the building without knowing anything about the expropriation plan by the government. So when a lease was made between the lessee and the lessor, when it turned out that this land was in fact in the area covered by the government's expropriation plan, the lessee wanted to get out of this contract. The lessee just claimed that this lease was voidable on the ground of a mistake as to the quality of the property, and the Supreme Court agreed. The mistake in question here, it was the one as to the quality of the property. The property which was the subject matter of this contract, so that it was, the list here, the list here would have to become voidable on the ground of a mistake as to what? A mistake as to not as to the subject matter of a Juristic Act, but the mistake as to the quality of the property. Okay, even though this property is a subject matter of the Juristic Act, but it is a mistake about the quality, not about the subject matter of the Juristic Act directly. Okay, so that the consequence is that the list here became voidable only. Okay, now one more case here. Okay, we have the case. A similar case indeed, about the doing something without knowing that the property in question was subject to an expropriation plan by the government. Okay, in this case, it was concerned with about the sale or the purchase. A was the buyer. A bought land. Okay, A bought land from B. So A was the buyer. B was the seller. Okay. At that time, A, the buyer, intended to use this land for what? For the construction of a factory, a canned food plant. But the thing is that at the time of making the contract, A, the buyer, did not know at all that in fact part of this land would be expropriated by the government for an irrigation canal, for making an irrigation canal. A wanted this land for running his business. In this case, for the construction of a factory. Okay. The thing is that when this land was in fact was to be expropriated by the government, then the intention to just use this land for the construction of this factory would be ruined. Okay, so that A, the buyer, argued that the agreement to sell, สัญญาจัดซื้อขาย was voidable on the ground of a mistake as to the quality of the property. Okay, and again, this contention was in fact agreed by the Supreme Court. According to the Supreme Court, the sale here was, the agreement to sell here became voidable because it was made under a mistake as to the quality of the property, okay? So that it was voidable. Okay, and the second one's 5-7. Now, let's have a look at one more case here. Right. Again, it was concerned with the purchase of land and a building without knowing, but not knowing about, the expropriation plan, but without knowing about the order of the authority pertinent to this land and the building. Okay. At that time, the building that was not there yet. When a person wants to construct a building, okay, we will have to do what? We will have to just make the application for the building, okay. We will have to just apply for a building. We will have to apply for building permission, okay. At that time, what happened is what? A, the buyer, and A, the buyer, B, the seller. A, the buyer, enter into an agreement to buy this land and the building from B. At that time, the building was not yet constructed. It was under construction. So the construction was just in progress. Okay, the building was not ready yet. The building was not completely built yet. The construction was just in progress, okay? A, the buyer wanted this building for what? For the operation of a hotel business. Right. The thing is that, at the time of the agreement in question here, what happens was just that there was an order. In fact, there was orders. Ordered by whom? Orders by the local competent official. The first order is to suspend the construction, okay, because the construction just did not conform to the plan. And the second order was the one for the demolition of part of this building. The thing is that, A, the buyer, did not know about these facts at all. A, the buyer did not know about these orders at all, and A was not told anything by the seller. Right. Can you say that, this is what? In fact, that this may be also fraud by silence. Remember, we have talked about fraud by silence. In this case, I'm sure that when B, the seller, knew this and did not reveal these facts to A, the fault on the part of B seemed to be quite large, so that it could also be, fraud by silence or non-disclosure, which we talked about last week, remember. But in addition to fraud by silence, in fact, the issue on the fraud by silence was not raised by the party in this case, but the party in this case just argued that the buyer in this case argued that the contract was made under a mistake as to the quality, so that the contract in question would be voidable, and the Supreme Court agreed as well. The contract here was made under a mistake as to the quality of the property, so that it was voidable. Right. So we can see that there is also duality of remedies. The parties injured may invoke that this contract was made by fraud by silence or non-disclosure, which made the contract voidable. And alternatively, it could be argued that this contract was made under a mistake as to the quality of the property, and it would have to become voidable. And the second one, 5-7. Okay, so it's up to the party to choose which remedy to be pursued. But in this case, the party the buyer did not invoke the principle of law on fraud by silence at all, so that the question considered by the Supreme Court seemed to be limited to just a mistake as to the quality of the property, okay? And of course, the contract was pronounced by the Supreme Court as voidable on the ground of a mistake as to the quality, okay? Now, what else to be the, oh my God, now 12:37, just a few minutes more, okay? One more case here, a lease of land. A lease of land misbelieved to be directly adjacent to the main road. The thing is that somebody just took a lease of the land, and the lessee was in the misbelief that that land was directly or immediately adjacent to the main road. But in fact, that land was not immediately adjacent to the main road. It was interrupted by one more lot of land. Okay, so that it was here that was a mistake about the quality of the property. So that the lease in question would have to be what? Would have to be voidable, because this quality of the property was essential in the usual course of things. Remember section 157. Okay, paragraph 2 also say that the mistake about the quality must be related to the quality which is essential in the usual course of things. So in this case, the Supreme Court held that the mistake in question was essential in the usual course of things, so that the lease in question would have to be voidable, so that it could be avoided by the party, and after avoidance, the parties would have to be restored to their original position, so that the lessee would have to return the land to the lessor, and similarly, the lessor would have to return the rent to the lessee. Okay, now. Let me just look at the time, okay, to whether or not it is sufficient to. Wait. Okay, a few minutes more. Okay, now let's have a look at another example here. An agreement to sell a condominium unit. The thing is that there was an agreement to sell here. An agreement to sell a condominium unit. That means a room, okay, in the whole condominium, okay? Just maybe one or two rooms in the condominium. Okay? There are two words, okay? First, condominium, and second one is condominium unit. Okay? The condominium unit, it is just the one unit in that condominium, okay? Condominium unit and condominium building, okay? If we talk about condominium building, we talk about the whole building. If we talk about a condominium unit, that is just the unit, the room in that condominium building, okay? The thing is that, let's say that, the buyer just bought this condominium unit. The agreement to sell, or สัญญาจัดซื้อขาย stated that this agreement to sell stated that this condominium building was located in the area consisting of 380 square wall, but in fact the true area is just 200 square wall. Why is measurement is a Thai measurement? We don't have the English, the English the equivalent in other countries. You may have acre as the measurement unit, but in this country we have wa. Okay, so the buyer believed that this condominium unit was located on the area of 380 square wall, but in fact the real area, okay, the real area is 200 square wall. This condominium condominium building was located in the area consisting of just the 200 square wall. So the buyer claimed that this agreement to sell was made by a mistake as to the quality of the property. Okay, the thing is that the Supreme Court disagreed because, according to the Supreme Court, okay, this was an agreement to sell. Agreement to sell what? Agreement to sell a condominium unit, not condominium building. So that the mistake here, it was not the mistake as to the property being the subject matter of the Juristic Act, because the agreement to sell related to the condominium unit, not the condominium building. So that it was not a mistake as to the what? As to the property itself, but it was a mistake as to the quality. Even though it was not a mistake as to the property, that was the subject matter of a Juristic Act. It could be the mistake about the quality of the property, okay? So that the agreement to sell in question became voidable on the ground of a mistake as to the quality, okay? So that the buyer could just avoid this contract. Okay? Now, one more case here. One more case here. Let's have a look at this picture, okay? We have, in this case, a compromise agreement. สัญญาประนีประนอมยอมความ but that is made for the partition of the estate. A compromise for the partition of the estate สัญญาประนีประนอมยอมความเพื่อแบ่งมรดก Okay, A and B enter into this compromise for the partition of the estate. This is the deceased person. This deceased person had this lady as the wife, but this lady was not the legitimate wife, because the two here, this man and this lady, they were not married. So that this wife was just the illegal wife or illegitimate wife. The thing is that when A made this compromise for the partition of the estate with B, A was in the misbelief that B was the legal wife. In fact, B was not the legal wife. But A thought that B was C's legal wife. Okay, later when A knew the truth, A just claimed that this compromise for the partition of this estate was voidable on the ground of a mistake as to the quality of the person. Okay, it was held by the court that no, it was not the mistake as to the quality of the person, but it was the mistake as to the legal status of the party only, not about the quality of the person. So that this, the compromise, okay, the made between A and B here was not voidable. Right. So sometimes it seemed to be what? It seemed to be quite arbitrary. Okay, that it's up to the court to say that, well, this mistake is about the quality or about the property, about the quality of the property or about the property itself. It is mistake about the persons or about the quality of the person itself. It is the mistake about just the legal status rather than about the quality of the person. Or is this a mistake about the essential subject matter of the Juristic Act or not? Right, so if I say the facts in the examination, you don't need to get worried. You have the right to disagree with the Supreme Court. If on the facts you believe that, well, this mistake, it is not essential. It is not as to an essential subject matter of the Juristic Act, then fine, but you have to give good reasons in support of your answers, okay? Now, the last thing which I need to say is this one. Even though the law just, even though the law invalidates juristic acts which are made by a mistake. But one thing which cannot be upheld by law is this. If the mistake, even though the mistake has been made, but it is occasioned by gross negligence, ประมาทเลินเล่ออย่างร้ายแรง in Thai, that is not going to give any ground, okay, for remedies, even though it is a mistake. But the law does not want any party to just have the benefit of this mistake. The law does not want any party to invoke this mistake for avoiding contractual liability. Okay, so this is pronounced in section 158. If a mistake under section 156 or section 157, it is occasioned by gross negligence of the person declaring an intention, such person may not rely on such mistake in his favor. Meaning that even though it is a mistake, the party who is mistaken may not just, invoke that as a ground for avoiding contractual, the liability or contractual obligation. Okay, so let's support that. Normally, that this mistake is, even though it is important, but you should not have made the mistake. It is so clear. Let's say that, I have two cars. One is Honda Civic, the other one is a Honda Accord. I place an advertisement in front of my house gate, indicating that I want to sell a Honda Civic. I put the word Civic in a way, I just put the word Civic using a very large font. And when you just, walk past my house, even though I make it clear with an extremely large font that I sell my Honda Civic, but you are mistaken. You are in the misbelief that I sell a Honda Accord here. Can you claim that this is a mistake as to the property? If on the fact I place an advertisement using a very large font, and I also display a picture of my Honda Civic, normally people who just walk past my house can see the word Civic very, very clearly, but you is the only one who just become mistaken that I sell my Honda Accord, and you just make an acceptance to buy to buy this Honda, this Honda. Okay, in this case we can see that your mistake is occasioned by gross negligence, so that you may not invoke the mistake in question, okay, to just invalidate the contract here. Okay, so it is a mistake about the gross negligence. The law of many countries also maintain the position if the mistake in question, even though it is about something very important, even though it is as to an essential subject matter of a juristic act, but if it is occasioned by gross negligence, it cannot provide an excuse. Okay? Now, the last thing we need to say is this one. Okay. Under Thai law, we can see that with respect to the principle of mistake, Thai law mainly or primarily seeks to protect the mistaken party. We can see that if A and B makes the contract, let's suppose that A alone is mistaken, B is not mistaken. In this case, if the mistake made by A, it is about something very fundamental. It may be the mistake as to the essential subject matter of a juristic act. Then this juristic act may be void, so that A can just claim that this contract between us, between A and B, is void. In this case, B suffers some injury. Even though B has not made the same mistake, B is not at fault. Does Thai law, does Thai law provide remedy in B's favor for this case? In the event where A invoked, in the event where A argues that this contract is void because of mistake made by A alone. The law does not protect B in this case. So in other countries, look at in English law. In English law, the principle of law seems to be focused more on objectivity, so that what is in a person's mind is unknown. If this case occurs in the UK, and English law applies, then the mistake by one party cannot be an accused. So that in common law jurisdictions, the law seems to be based upon the objectivity, not subjectivity. Everything will have to be determined by the understanding of a reasonable man. Okay, if A sells a Honda Civic, okay, and B just think that A is selling a Honda Accord, in this case, B cannot just argue that this contract is made. This contract becomes void because what is in B's mind is unknown. So that when B, say that he wants to buy a car from A reasonable man will understand that B wants to buy a Honda Civic because A sells a Honda Civic. So B, even though B is mistaken that A sells an Accord, B will have to take a Honda Civic because the intention will have to be determined by the understanding of a reasonable man. Okay, this is something brought to you as additional information for the purpose of comparison. Okay, but don't worry about this one. Last thing is that when common law and civil law seem to be based on different approaches between objectivity and subjectivity. Okay, in the world, attempts have been made to make rules in contract law, rules for application to international commercial contracts. These attempts can be seen in the unilateral principles of international commercial contracts 2016. And if you see this instrument, you will see that there is Article 3.2.2. This article, it is article on mistake. And we can see a very good balance between the objectivity and subjectivity. But this is not something which we talk about in this class. If you are interested, then you have to proceed to pursue your legal education in the Master of Law degree, program. Okay, that's it for today. Okay, I think that means that you are tired. I am very, very tired. Because the second half of the lecture lasts for more than 2 hours. About 2 hours. So that I think that means the time is flying indeed. So that's it for today. Next week, we are moving on a new topic. I'm thinking whether we should just spend some time talking about English law. I think that we will talk about comparable doctrines in English law. We have seen principle of law in the Thailand regarding the mistake, regarding the fraud, regarding the jurists. We will see the parallel or comparable doctrines in English law for the purpose of comparison. Again, this will be also covered in your midterm examination, so pay attention to this very, very well. Thank you very much for today, and good luck. See you next Monday. Thank you. Bye-bye.